Imagine a U.S. raid on a foreign presidential palace in broad daylight and the sitting head of state ending up arraigned in a Manhattan courtroom 3 days later. No, this isn't a movie. On the 3rd of January 2026, U.S. forces carried out an operation in Venezuela that resulted in the capture and translocation of President Nicolas Maduro and his wife to federal custody in New York. What legal papers allow the United States to do that? Is it a law enforcement action or an illegal use of force under the UN Charter? And what does this mean for every leader on the planet? Stay with me, because the next 12 minutes will walk through the law, the history, the likely courtroom fights, and the geopolitical fallout. You'll also hear the one legal question that could determine whether this ends in a conviction or a global precedent. Hi, welcome back to Shadow Docket, where we unpack the courtroom files behind the biggest legal dramas. Quick note up front, this is for educational purposes only and does not constitute legal advice. If you need case-specific guidance, consult qualified counsel. Over the next few minutes, I'll cover the U.S. legal basis for the operation, the international law objections, the doctrine of sovereign immunity and how courts have treated it, historical cousins to this case, the defense playbook we should expect, the immediate diplomatic shockwaves, and why this could reshape prosecutions of heads of state for decades. And stick around, I'll flag the one courtroom fight that could rewrite immunity law in the United States. But first, the facts. Let's start with what we know. On the 3rd of January 2026, U.S. forces conducted an operation reported by multiple outlets under the operation name Operation Absolute Resolve inside Venezuela. The operation resulted in the capture of President Nicolas Maduro and his wife, Celia Flores, and both were transported to the United States and arraigned in the Southern District of New York on January 5. These were not newly filed charges. They're rooted in indictments first unsealed in the SDNY in March of 2020, drug trafficking, narco-terrorism, and related conspiracy counts that have been pending for years. Media reports also said that the U.S. had offered a reward, reported at $50 million on the 7th of August 2025 for information leading to Maduro's arrest or conviction. But here's the thing, how you describe that action matters enormously. The U.S. framed it as a law enforcement arrest of an indicted fugitive. Venezuela and many other states called it a kidnapping and an illegal use of force. Which description sticks will shape legal outcomes and diplomatic ripples. There is no close precedent for this exact sequence. Under public international law, the use of force against another state's territory is generally forbidden under Article 2, Paragraph 4 of the UN Charter, unless the action is authorized by the UN, Security Council, or justified as self-defense under Article 51. So the immediate international objection was that the U.S. operation violated Venezuela's territorial integrity and the Charter. The UN Secretary General publicly called the action a dangerous precedent at an emergency Security Council meeting on January 5, and several states, including China, Russia, and Cuba, condemned the operation. But, and this is crucial, states sometimes argue that capturing fugitives is a law enforcement function, not an armed attack. Would that make it lawful without host state consent or Security Council approval? Most scholars say no, a forcible cross-border seizure of a sitting head of state looks a lot like an act of force. The legal distinction between policing and war blurs when special forces cross a border to seize a president. So can you lawfully go into another country and arrest its leader if you call it policing? Coming up, the domestic immunity arguments and why U.S. courts could face the constitutional fight of the century. Now let's turn to sovereign immunity. Under customary international law, incumbent heads of state enjoy broad immunity from prosecution in foreign domestic courts for official acts. In U.S. law, the doctrine is layered. Foreign states enjoy immunity under the Foreign Sovereign Immunities Act for civil suits, and individual foreign officials have been treated differently in different cases. The Supreme Court's Samantar v. Yusuf decision left open some unresolved issues about liability for foreign officials, and civil decisions like those involving Pinochet or Noriega provide analogies, but none of those involve the forcible cross-border seizure of a sitting president, followed by immediate domestic criminal prosecution. Here's where it gets interesting. Maduro's defense can, and almost certainly will, argue incumbent sovereign immunity. They're likely to say a sitting head of state is immune from criminal jurisdiction in U.S. courts for official acts. The U.S. response may claim exceptions, for example, that narcotics trafficking is not an official act and therefore not protected, or that immunity does not apply to criminal acts regardless of official title. Expect a thunderous clash over whether immunity covers alleged criminal responsibility for transnational crimes. But wait, remember Manuel Noriega. The closest U.S. analog is the 1989 capture of Panama's Manuel Noriega. U.S. forces invaded Panama. Noriega was eventually captured and brought to the Southern District of Florida, and he was prosecuted. But there are differences. Noriega was not the recognized head of state, acting with full diplomatic immunity in the same way, and the international context and legal framing were different. Other examples include the surrender or extradition of leaders after losing power. Charles Taylor surrendered and was tried by the Special Court for Sierra Leone. Slobodan Milosevic was tried by an international tribunal after being deposed. The International Criminal Court has issued indictments against sitting leaders like Omar al-Bashir, but most states did not arrest him when he traveled. None of these are a perfect match because they lack the combination we saw here: a kinetic cross-border seizure of a sitting governing president, followed by immediate domestic criminal prosecution in the capturing power's national courts. If history gives us hints but not answers, what will the courtroom decide? Let's map out the core legal fights. The prosecution will rely on existing SDNY indictments, narcotics trafficking, narco-terrorism, and conspiracy counts first unsealed on the 26th of March 2020. Prosecutors will assert extraterritorial jurisdiction under statutes that reach international narcotics conspiracies and will argue any immunity is inapplicable because the acts alleged were criminal, not official state acts. They may also frame Maduro as a fugitive who evaded lawful process and therefore was subject to arrest. On the other side, the defense will likely file immediate immunity motions and jurisdictional challenges. Expect arguments that an incumbent head of state is immune from criminal prosecution in U.S. courts for official acts, that the capture was unlawful under international law and therefore any evidence or confession is fruit of the poisonous tree and should be suppressed, and that separation of powers concerns mean the executive branch cannot unilaterally extend U.S. criminal jurisdiction onto a foreign head of state without congressional authorization. They may also pursue habeas or due process claims, challenging detention conditions. But here's the thing, courts rarely face this exact issue. Early decisions on immunity could end up at the U.S. Courts of Appeals, and given the constitutional stakes, likely the Supreme Court. Imagine the court having to decide whether the President of the United States can authorize a cross-border capture and then prosecute a sitting foreign leader in domestic courts. The separation of powers and foreign relations implications alone make this a monumental case. Here's a quick legal test. Would immunity apply if the alleged offense was drug trafficking rather than an official diplomatic act? That question could be dispositive. Outside the courtroom, the immediate fallout has been severe. The operation prompted widespread diplomatic condemnation. China said it was unacceptable for states to act as judge, jury, and executioner. Russia and Cuba condemned the raid. Multiple Latin American governments expressed alarm. The UN Security Council met on January 5, and the Secretary General warned of a possible intensification of instability. Reported casualty figures from the operation varied Venezuelan sources, and some media cited figures in the 40 to 80 plus range, but numbers remain disputed and independently verified counts are incomplete. Practically speaking, even if the U.S.